Okay, so good afternoon. Thank you so much for joining us today for MVLS's training on quiet title actions. So I am Timothy Chance. I am a Tangled title attorney at MVLS, and I oversee our My Home, My D program, which is geared towards community and housing stability here in Baltimore and across the state of Maryland. So major problems we've seen as part of My Home, My D project is folks dealing with tangled titles, folks who are living in homes where their names are not on deed. And these tangled titles keep these families from accessing critical resources and makes their home so much more likely to be lost to either mortgage or tax foreclosure. So in addition to estate planning and estate administration to rectify this issue, another approach to resolving tangled titles and keeping homes in families is the use of quiet title actions. MVLS is committed to preserving our clients' housing, and we are excited to have Thomas Valkenet here today to speak on quiet title actions. So Thomas is the co-founder of Young Valkenet and has over 3 decades of experience in real property matters. And before I hand the reins over to Thomas, I just want to do some quick housekeeping. So firstly, this training is being recorded so you can access it later. So we actually just started recording just now, and we highly encourage questions. So we want this to be as interactive as possible. So if you have any questions during the presentation, please just put them in the chat or the Q&A. I'll be monitoring that, and I will just relay them to Thomas as they come in. So without any further delay, Thomas, you take it away.
Outstanding. Hi, folks. Welcome. Tom Valkenet here. I actually have 35 years at the Maryland bar, and mostly emphasizing real estate curative type litigation. I'm going to show you a PowerPoint presentation. So I'm going to put on the share screen function right now so you can see the slides. All right, there you go. All right, you should all see a blue slide, quieting title in Maryland. Marvelous. All right, so welcome. We all share an interest in property rights, and you are among the few willing to extend your professional talents to assist less affluent property owners. My work is largely in Baltimore City. It's an old city very much in flux, where efforts to redevelop and repurpose city properties always runs headlong into title defects that must be resolved and removed. The work we will discuss today is essential if we're going to preserve and promote free alienability of title, which I believe is probably the most foundational of our rights. So our hour together will include a general overview of the Quiet Title Act and situations where you would use the act to resolve title disputes. I assume you all have a general knowledge of real property law and litigation, as both are needed to prosecute and resolve claims under this particular statutory regime. So each slide, and there's only 9, we've only got an hour together. Each slide includes some photographs depicting property from my law firm's past or present cases, and I'll share a bit about each photo and graphic as they appear. You may even recognize issues that you've already encountered in your own practices. It's my intention that the anecdotes relating to the photos and the graphics will illuminate some aspect of quiet title cases that you may encounter in your own work on behalf of MVLS clients. I don't have them here just because I like to tell war stories. The text of each slide will generally track the requirements and admonitions of the Quiet Title Act, sprinkled with a few practice tips born of my own years of real estate and litigation practice and real estate brokerage. As a fellow MVLS volunteer lawyer and an MSBA mentor, I am available to you for any follow-up questions. Even if the questions don't come in today, you may think of something over the next few days. My direct dial is 410-364-4543, and my email is tcv@youngandvalkenet.com, or you can find me on our website. At most, a call might cost you a cup of coffee. So let's begin. This first slide depicts an area of Fells Point on Lower South Broadway. Before it was improved to its current state, the lending banks required that all title defects be cured, and I was hired by the developer to get this done. This project presented with all of the most typical Baltimore City title defects, and a few of them included conditions on the ground that did not match what was described in the deeds and plats. For example, one entire city block was constructed 8 feet wider than it was drawn on paper back in the 1700s. And to further complicate matters, the deeds and plats for this block exist in both Baltimore City and Baltimore County, since Fells Point was once known as Jonestown and was part of Baltimore County long before it was annexed to Baltimore City. Another problem arose from unused and non-existent sally ports. This is a big issue throughout the city. We've all seen the common use sally ports that allow folks to walk through row houses to access rear yards. The entire city was once a warren of these backyard alleys. Often they were constructed to permit homeowners to get their horse to the rear of the house and into the stable. Over the decades, sally ports and side yards were often enclosed by adjoining owners to enlarge their homes, despite existence of recorded use and common easements that would allow you and me to walk through those same sally ports. We also encountered efforts by families with common last names like Smith or Cohen to simply annex adjoining property through self-serving rogue deeds that randomly added property descriptions. These deeds had no links to any prior deeds and existed in direct contradiction to some other existing deeds. And the most common defect was the incomplete devolution of title caused by death, where an owner or partial owner had a will that was not followed by a deed, or there was no will, or there was no living heirs at the time of death. Maryland now requires a deed out of an estate, but that was not always the case. Many ancient transfers of ownership were evidenced only by recital in a will, which may or may not have been the subject of a public probate litigation. So tracing lines of inheritance through all these avenues was necessary, because you can't quiet title until you know your adverse parties and can serve them with court process. Our lawsuits to quiet title on South Broadway involved suing descendants of the original Fells family, defunct corporations, and unknowing heirs of the long dead. The time spent by my office researching in the Maryland archives on ancestry.com, visits to various graveyards to rub gravestones, and direct contact with heirs and descendants around the world cost this particular client in excess of 50 grand, separate and aside from actual litigation costs for our work in court. And all of this work was performed to achieve final judgments under the Quiet Title Act. And so, whether you're dealing with an MVLS, a relatively impoverished client, or the largest developers, you're going to find that the title issues are the same. All right, we're going to move on now. And it would be nice if here we go. Forgive me, it's, it should be advancing, and there we go. Can you all see that?
It still looks like it's on the same
title. It does. It does, doesn't it?
Yep.
All righty. And for the life of me here, let's, I think I'm screen sharing the wrong one. Bear with me, folks. This was. All right, I think this should do it. My goodness. Still not showing it, huh?
Not yet, no.
All right, I'm going to restart it. There we go. You with me now?
Not yet.
There we go.
There was a slight delay last time, though. So.
Gotcha. We should be looking at a slide that says when to consider quieting title.
I've not seen it so far.
My goodness. All right.
Yes, there we go.
All right, folks, the difficulty is entirely mine. I'm sorry for that. All right, here we are. First, the text on the left of this slide. Like the Fels family issues described in the first slide, a dangling interest is created where an interest in a deed is not completely or properly transferred. Imagine a joint tenancy with two owners. Ordinarily, death of one joint tenant means the entire undivided interest in the property is now owned by the remaining joint tenant as a matter of law. My wife will tell you that I make inappropriate comments during medical dramas when a doctor calls time of death and I follow it with, and all his joint tenancies are now dissolved. However, unlike a tenancy by the entireties created by marriage, an ordinary joint tenancy can be severed by very mundane acts of one or the other, entirely without the knowledge or understanding of a layperson, such as execution upon the interest of one joint tenant by his individual judgment creditors. That changes the joint tenancy to a tenancy in common, and the two owners may never be aware that it has happened. After the judgment creditor is paid off and the writ of execution is released, the tenancy in common does not revert to a joint tenancy. Now, imagine one joint tenant dies and the remaining joint tenant believes she owns the full 100% fee interest, and she proceeds to sell that interest to your client. When your client seeks financing, bank counsel will likely require that the dangling interest of the dead joint tenant be accounted for, and that may involve opening an estate. It can involve obtaining waivers of inheritance from heirs, or it may require transfer of that 50% interest to one or more heirs and purchase of that interest by the remaining joint tenant. It might even trigger an adverse possession claim against the estate and heirs. This is just one variation, and there can be hundreds. Now, the next point, physical defects, they're like the Fells Point example from the prior slide, where a city block is 8 foot wider than written plat and deed descriptions. And this created for us a gutter running down the middle of a city block, as all the deed descriptions stopped short of meeting in the middle. Over several hundred years, some owners enclosed parts of that gutter, others planted trees and gardens or built garages over it. Now on this slide, the plot at the top right falls into the category of a case involving a physical defect. It depicts a Gaithersburg development on the former site of a United States Nike missile site. Until the early 1960s, as a result of the Cold War, the United States had erected a system of missile silos around the country. The missiles are long gone, but the easements that were created around the silos remain. And I'm going to use the laser pointer here on the screen, and I'm highlighting, it's like a reverse letter L in white. And that area that I'm tracing with the laser pointer on your screen is the area of the blast zone around the missile silo. There was this easement was like a donut that went completely around this land. And so like a donut, each silo was surrounded by this blast zone easement. My research, however, suggested that these blast zone easements were more likely created as a basis to keep protesters far away from the silos. But rolling forward to the present day, the government has either sold or redeveloped the old missile sites. The blast zone easements, however, remain as impediments to development. In this case, the government was leasing office buildings on the former silo land while denying our own client the right to build competing office buildings within the blast zone easement areas. Our firm brought a federal lawsuit for abandonment of the easement areas through the affirmative act of removing the missiles. Now, there are very special statutes of limitation for suing the U.S. government on title issues, and you generally cannot press adverse possession claims against the sovereign, whether king or democratically elected representational governments. Our lawsuit led to a very expensive purchase of the blast zone easements from the GSA. Now, this same issue routinely arises all over Maryland from abandoned railroad beds and rights of way. For at least a decade, our firm clashed with a serial litigant who had purchased railroad rights in Carroll County at tax sales, and then spent years extorting landowners with threats to sever driveways, landlock farms, or fence off pastures. He made a fair return against some impoverished homeowners who did not have title insurance or funds to hire a firm like ours, and he would often demand $10,000 per homeowner just to release his claims. Now, also on the slide, there's a house image on the bottom, and that house image depicts a current case we're investigating, and it relates to the last bullet point about wrongly taken judgments that affect title. As good as this house appears, you'd be surprised to learn that the plaintiff in a tax lien foreclosure of rights of redemption case had petitioned the court for a very special order predicated on the alleged poor condition of the property. In a case foreclosing redemption rights, the statute sets a 6-month period before a tax certificate holder may sue to foreclose on those redemption rights. However, that period is shortened to a mere 3 months if the plaintiff can demonstrate that the house is in such poor condition that it is a blight and must be immediately repaired. By obtaining a letter from Baltimore City, a redemption case can race to final judgment in 6 months or less. After all, nobody wants a blighted property that poses risks to health and safety of Baltimoreans living nearby. But in this case, and I suspect other cases involving the same law firm prosecuting the case, the property was in perfectly good repair when the affidavit was given to the court. Now, this now requires us to vacate a final enrolled judgment on the basis of fraud, mistake, or irregularity. And how did we uncover this? Well, our investigation involved looking at city permit records, interviewing contractors, speaking to tenants, and looking at MLS listings with past photos of this same property. This owner may still lose the property, but judgment should not have been based on a shortened deadline for response triggered by a gross misrepresentation made to the court. The letter from the city was undated and unsigned, making its provenance very suspect. The number of improperly taken judgments to foreclose redemption rights in the city is shocking, and likely a very common issue amongst those seeking MVLS help. We could do a whole hour on this topic alone. Moving on. Now, you can find the Quiet Title Act in the Real Property Code, Section 12, Chapters 801 through 811. If you don't own the hard copy and if you don't pay for a legal database, you can find free online access to the code through West, and you can also use terminals at the bar libraries. The slides that follow will generally run through the requisites for a quiet title action. First, there's a very important aspect, though, of quieting title that will create obstacles for you as MVLS volunteer lawyers. Where interests are to be obtained through purchase, assignment, estate administration, or statutory redemption, money must be paid. It is only in adverse possession matters that title interests can generally be taken without payment of value. Where our firm represents a title insurer, a bank, or a developer, there usually exists pots of money to obtain and secure these interests. But the MVLS litigant is uniquely different. Having qualified for your help and my help by demonstrating a lack of means, you must advise the client of the limitations of your ability to resolve certain title issues. Your engagement might be pro bono, but others are not compelled to surrender deeded or inherited title interests for free. If the MVLS client cannot ultimately pay value for certain property interests, your efforts may, in the end, be in vain. Now, the image in this slide depicts a drive in Annapolis, near the Capitol, constructed in the 1800s. It's a circular path that served as access for dozens of homes right near the Capitol building. However, the owners of the historic Randall Bordley house, or Bordley Randall, I forget how it's pronounced, drove the wood post you see into the road, thus preventing vehicular access to all homes around the circular path. The case required research on the size and weight of various forms of conveyance when the roadway was constructed to support our argument that vehicular access, albeit non-combustion engine powered vehicles, had been objectively contemplated by the persons that designed and constructed this pathway in the early 1800s. Our research also found an ancient news report of experimental combustion engine vehicles in New England at that time, all in support of our legal argument for access. We won on summary judgment and the post was removed. A gate was erected and all residents now have their own keys. And we did that utilizing the quiet title statute. The images on this slide depict a Canton, Baltimore City block across the street from the Natty Boh building. On the left, you see an entire city block raised by my client, which had purchased the entire block at an auction sale. The white concrete slab that you see in that picture, and using my laser pointer, I'm circling it there. That slab is all that remains of a meat storage refrigeration room that was part of the sale. The seller's widow contended that she had inherited title to those lots covered by that concrete slab, and a lawsuit for reformation of the auction contract and several deeds that followed the auction ensued. Part of the evidence at trial was the picture on the right, taken in the 1970s, showing the interior of the building that used to exist on that same spot. The client testified that the pre-auction walkthrough included this space with statements by the auctioneer that this is all included. Evidence like this supported judgment in favor of the auction purchaser and negated several deeds that had been recorded by the seller's widow and now allows development of this site. And this all was done utilizing the Quiet Title Act. So let's start with the nuts and bolts. Please understand that this statute describes a mechanism to assert and resolve substantive rights arising from other causes of action. Now imagine a client asking you, will you file a quiet title action for me? Your immediate question would be, for what? And the statute responds to your question in a very cavalier fashion. It says, quote, to establish title to real property, end quote. The underlying question for you as learned real estate counsel is the follow-up, why? It is in the why that you define the causes of action to be embedded in your quiet title complaint. I start with I personally, and it's not in the statute, but this is the manner of our practice over the years. I start with the desired court order and I work backwards. A quiet title case rarely seeks money damages, and so the relief you seek falls into these categories. First, you might want to make someone do something, such as honor a boundary, move an impediment, or reform an agreement. Next, you might want to make someone stop doing something, to cease an encroaching activity, to stop accelerating surface waters, to stop slandering your title to others, or to stop enforcing a stale or illegally obtained lien. You might anticipate asking that the court declare your client's ownership of something by adverse possession, or your client's right to continue use through an adversely obtained easement. You might ask the court to declare that someone else has no claim to adverse possession or use over your land, which is just the flip side of the prior point. You might ask the court to declare a lien or claimed interest in your land as invalid and not enforceable. This could be an executory contract of sale, a right of inheritance, or a tax lien. You might ask the court to declare your claimed interest in land of another is valid and should indeed be enforced against their protests. And you might ask the court to declare relative ownership rights in a property among several people. Who owns what and what percentage of it? Are they joint tenants? Are they tenants in common? Because that affects who can inherit, who can sell, and how they might do it. But any claim arising because of or involving any one of these claims to any interest in a title to land is properly alleged within a quiet title action. The filing of a quiet title case gives you the power of lis pendens, and that's just a fancy Latin phrase adopted in the statutes, standing for constructive notice to the world. And a quiet title action further places the property into the constructive possession of the court. You may have heard the phrase custodia legis. These are very powerful tools. For example, where our firm has represented real estate brokers seeking to collect commissions, where their broker agreements declared the right to a commission to be an interest in the property, we filed complaints hours before a settlement that both blocks settlement from occurring and forced payment, or at least a negotiation over that payment. Lis pendens can serve as a valuable placeholder for the claimed lien or interest, as the owners may continue to apply for loans, incur judgments, or try to quit claim their interest away before you can obtain the relief you need for your client. Now, I'm going to share a clip with you to underscore the importance of beginning your case with at least an outline of the final order, and of all those categories of requests, what you want the court to give you. So we turn now to that epic courtroom drama, The Notebook, where Ryan Gosling plays a Maryland Circuit Court judge presiding over the quiet title case brought by an MVLS volunteer lawyer, played by Rachel McAdams. So let's watch as court and counsel discuss the appropriate equitable relief to be granted at the end of the case.
You stop thinking about what everyone wants. Stop thinking about what I want, what he wants, what your parents want. What do you want? What do you want? It's not that simple. What do you want? What do you want?
And there you go. The end of so many quiet title cases when the judge has heard all the evidence and just doesn't know what the lawyers are seeking. And that's why I always start with the order after interviewing the client and asking them what do they want, and then refining that within the causes of action that I know that are available to try to achieve that result. So don't be Rachel McAdams at the end of your hearing. Start the case knowing what you want. So let's draft your complaint. Having done your preliminary research and factual investigation, your precatory paragraphs will be detailed and full of specific citation to the land records, plats, surveys, and affidavits. Your factual recitation will lead the reader and ultimately the judge to conclude in your favor by the time they actually finish reading the factual recitations. And this is an approach we take with motions for summary judgment, motions to dismiss. We try to persuade by the end of the factual recitation before a single case or statute is discussed. You are bringing very complex matters to the court, and so I counsel exactly that approach. The images in this slide come from an active Baltimore County dispute that we are now handling. The plat on the right side of this slide depicts 4 separately owned parcels that share a gravel road for access to a public highway, exiting to the public highway at the top of the plat. 3 of the properties have boundaries that meet at a point located dead center of the road. That meeting point is shown in the photo image on the left, where a survey stake is visible in the center of the drive. And with the laser pointer, I'm circling that point where the survey stake is, and going to the right, showing you roughly where that point is on the plat. The dispute arises from the refusal of the owner of the land, located to the right of the survey stake, to permit a new owner of the land, located to the left of the survey stake, use of the shared drive for construction traffic. The new owner, our client, intends to build his family's homestead on the 50+ acres of fields and woods below the drive. The objecting owner has been chasing Baltimore gas and electric workers off the property, and he's been harassing surveyors and architects visiting the parcel. This fellow just doesn't want any neighbors. A lawsuit has been filed to establish that all 4 parcels that you see have title chains that describe the same drive, and that it is described as, quote, use in common, which is a very common way to describe shared drives and parking lots. And that use in common easement burdens all 4 parcels, including the areas shown in the picture. The complaint also includes claims for injunctive relief and declarations about the written deeds. The neighbor has erected chains to prevent our client from entering or leaving his parcel, and the neighbor has called county police, which has caused us to consider additional wrongful imprisonment and other abuse of legal process type torts. The prevailing party in this case will be determined by the title documents, and our star witness will be the title abstractor. All relief will flow naturally from his analysis of the deed language incorporated in many documents over the last 90 years. Drafting our complaint underscores the importance of the initial pleading stage. It was important to clearly understand and to clearly identify the various property interests affected by our claims. You will face the same questions. Who is in the title chain, or who is in actual possession and who must be named as a defendant? In an adverse possession case, one party is in title and the other may make claim under color of title. In a trespass case, the plaintiff might be the owner or a tenant in possession via a leasehold interest. In a declaratory judgment action pleaded in conjunction with your quiet title count, a lien holder may be a defunct entity with one or more surviving former owners. Do you name the former shareholders or members as trustees of the defunct entity's assets? Well, for that, you go look at the tax code, and it'll give you some instruction on that. If you have dead, infirm, or young persons in the dispute, you will have to determine whether and how they can be named in your case. If an estate was opened, is the personal representative still around? Must they be replaced? In some cases, you might determine that a special administrator can be appointed for the limited purpose of handling a single asset or property interest. With disabled persons, is there anyone with power of attorney? Must you file for appointment of a guardian of the property? Knowing what property interests you are litigating ineluctably will lead you to consider to whom and how those property rights have devolved, either by descent, inheritance, deed, or court order. And that's going to help you define your order of presentation and define the parties that are necessary and indispensable for your dispute. And that's going to help you draft your complaint. Now let's talk about jurisdiction and venue. Constitutional due process, both state and federal, requires service of process on the defendants. Consider that in establishing your client's property rights by judicial determination, you are eliminating or diminishing the perceived and actual property rights of others. Where property ownership and the right to exclude others from real property is a basic precept of this country's founding, extending due process of law to the litigants is perhaps the most important element of your case, both in the drafting and in the execution. Extending due process becomes a largely mechanical project for you. It involves locating, serving, and demonstrating the efficacy of process to the court. You can obtain no relief until you demonstrate good service, either actual or constructive, on every party identified in your initial pleading, encompassing every property interest you hope to address. More often in quiet title cases than in any other practice, you will have to administer claims against unresponsive, disinterested, and distrustful parties. You need to know how to obtain defaults, how to obtain consents and waivers, and you must be willing to even knock on doors, work your phone, the equivalent of talking a horse into drinking your water. My practice, which is generally well funded by institutional clients, allows me to offer modest payments in exchange for consents, signatures, affidavits, even quitclaim deeds. Our MVLS clients, however, are not so lucky to be flush with discretionary cash, and this brings us back to one of my initial admonitions. You may not be able to afford an MVLS client complete relief if that relief might require monetary payment to obtain or release an interest or to obtain consents and waivers. Courts do not strip property rights without requiring payment of fair market value, except perhaps in adverse possession cases or declaratory judgment actions directed at stale and unreleased liens. Now, before we move to the next slide, the plat on this slide comes from a lawsuit brought by two very wealthy Washington, D.C. lawyers who had purchased a small farmette off of General's Highway in AA County. They were not interested in a farmhouse that existed on the parcel. They were interested in a barn located next to the farmhouse, specifically to store a collection of their antique cars. In this all-cash transaction, there was no lender to delay settlement where the survey of the boundaries and the easements had not yet been completed. In this case, the busy DC lawyers had ordered a boundary survey and it was not completed on the settlement date. However, these same DC lawyers refused to postpone even one day, citing their very busy DC lawyer schedules. And the plat you see was produced to the parties one day after settlement. And where I've circled in red, a 1960s era State Road Commission condemnation action had reduced the parcel to accommodate creation of General's Highway as we all know it today. As a result of this road widening project, the boundary for the property ran straight through the middle of the barn. In essence, the very barn they were purchasing to store the cars only belonged to them to the extent of one half of the structure. This was a big oops that triggered a lawsuit where these same busy DC lawyers sued everyone involved in the deal, but they were poised to lose on summary judgment for their own contributory neglect. They had simply refused to wait for a completed survey before proceeding to settlement. On the next slide, you will see the State Highway Administration plat that was discovered by the surveyor. And it's a good example of an interest that isn't easy to find, but it's absolutely essential that you find it if you're going to file one of these cases. So enjoy this plat. It's like a plate of spaghetti to me. I still don't understand all of the lines that it contains. Somewhere in this mess is the boundary that cut the busy DC lawyer's barn in half. And fortunately for them, my clients allowed me and others to lobby the SHA to release the condemned land as surplus property. And once the state declares surplus property, you're able to purchase it. And we were able to thus restore the full barn to the plaintiffs in exchange for payment of money. My expert was able to demonstrate to me and to this SHA that the area of the barn had not been used in the creation of the new General's Highway, and that the SHA had no longer needed to own this strip of land. I would have enjoyed an outright court win on our pending summary judgment motion, but in the end, property rights were restored. I felt it would have been unfair for the state of Maryland to retain an interest for which it has no practical use. But the point of sharing this slide with you is that you've got to surround yourself with some expertise. I was not competent to dig this out. I remember the references in the deeds. I didn't fully understand them. I hired a competent title abstractor that I've worked with for 20 plus years. He got deep into the archives and he found this for me. So the land records mean many things, not just going down to the courthouse. The smallest of references in a deed will bring you to a document like this, which was stored only in the records of the State Highway Administration. So congratulations. You're about to resolve your case through final court disposition. Now that you have winnowed the parties through default, through purchases leading to partial dismissals against certain defendants, and even a few consents obtained after negotiation with other of the defendants, you must now appear at the trial or disposition hearing. There are no default judgments awarded on procedural grounds. The statute plainly instructs that, quote, plaintiff shall submit evidence, end quote. In most courts, this means an in-person trial event where you may be the only person in attendance. You may have disinterested or confused pro se defendants standing next to you. You might have submitted a bench memorandum in advance of the hearing. You may have even filed a motion for summary judgment that is now ripe for hearing. All of these scenarios are possible. You have to assess how to best bring your case to issue and to final disposition. I favor trial dates. A trial date is truly the last stop for the claim train. A summary judgment motion, if denied for failure of some exhibit or affidavit, just means you must do it over again at trial. I've got one of these now. I thought I drafted an ironclad summary judgment motion. The court posed a singular question about one error that had not been properly accounted for in an affidavit. And I either have the choice of filing a new summary judgment motion with a corrected affidavit or just going to trial in about 2 months. But I do favor submitting the equivalent of a summary judgment memorandum, which we call a bench memorandum, in advance of the hearing. This is easier in many instances than walking a judge through arcane property concepts in the middle of his or her busy docket. There is always the risk of a judge not reading your bench memo, because remember, most circuit judges are not assigned a case until 1 or 2 days in advance, as we all know. But at least you will have taken the time and effort to order your own presentation, even if they don't read the darn memo. Now, I recall one Baltimore City case where my expert was my former real property law professor, Royal G. Shannonhouse III. And once he was seated in the witness chair, he and the judge had a 20-minute discussion about basic property law while I watched from the trial table. At the end, the court observed that it had not dealt with serious property law since law school and was deeply appreciative of the expertise that we had brought to court. And not to mention that Mr. Shannonhouse is a charming Southern gentleman to speak with. And I won, and I did it with very little speaking in the process. My expert carried the case. In most cases, if you are careful and thorough, your ordered presentation will result in a rubber stamp outcome for your client. Judges are most concerned about service, due process, and the completeness of the remedies you are demanding. It's up to you to give them a clear roadmap supported by the case law and statutes, and you will inevitably obtain your relief. Now, remember that proposed order. I've harped on it a few times. The one that has been guiding you throughout discovery and preparation, you use it now to order your presentation or to draft your bench memorandum. You will order your affidavits, your photos, plats, deeds, testimony, consents, assignments, partial dismissals, defaults, case law, and statutory authority, all of it. You've worked hard and you've earned the right to be eloquent now. And never forget that you are also creating a reputation for yourself before the judiciary. You do the work in the first few cases, it's going to be easier because the judges are going to rely on your thoroughness. And you're going to present your case even with the warts and the scars, and you're still going to obtain your relief. Now, a cautionary note, and my apologies to any of you that were law clerks for judges, but do not count on a judge's law clerk to do the research for you or to properly explain real property matters to the judge. Here's an example. In advance of a court hearing on final disposition of a quiet title complaint, once I received a call from a judge's law clerk. He asked that I provide a specific pinpoint citation to a Maryland case that supported my bald assertion that the Maryland Circuit Courts must follow a holding of the Supreme Court. His exact question on the phone was, why does Maryland have to follow the Supreme Court? I let it marinate for a few minutes, and I asked another lawyer from my office to travel to the courthouse where he had a quiet conversation with the clerk. And we avoided catastrophe. And not catastrophe on our end, but probably catastrophe involving their young career. So here we are at the final hearing. It's over. You've won. The court has signed your proposed judgment order. Now, on the left of this slide, I'm going to share with you the final scene from the movie The Candidate in 1972. Robert Redford's character has won his first political campaign. He's now a United States senator. The problem is that he's made no plans for after victory. Now imagine for a moment that you've proudly returned to your office, you've described the hearing to your client and your colleagues, and you're now luxuriating at your desk with your favorite coffee, savoring your victory and rereading the signed judgment order.
I don't think there's any sound coming through.
Oh, well, I'll highlight it for you here. While people clamor at the door, Mr. Redford sits on the edge of the bed, looks at his campaign manager and says, "What do we do now? He's won. What do we do now?" Well, folks, your work does not end with the stroke of a pen by the judge. A quiet title action concludes with recording. Interest in real property must be recorded. Think of the statute of frauds that says that the sale of an interest in property must be in writing. The Quiet Title Act continues the same theme. Our public records involving land function because they are universally counted upon to properly reflect all title interests affecting title to a parcel. So let's hope that you drafted a proposed order that meets the requirements for recording under the Recording Act, yet another statute you're going to have to go read. And let's hope further that you included language to exempt any adjudicated transfer of an interest from transfer taxes that your MVLS client may not have, and that are based on the assessed value of the interest being transferred. You don't want to be forced to file a post-judgment motion to revise, alter, or amend a final judgment simply to address your drafting omission. That might also mean you have to serve or reserve lots of people that you negotiated out of the case or dismissed out of the case. But you know what? Other than that, good job. So I wish you all the best of luck. Go do some good for the MVLS and for the citizens of Baltimore. And remember, I remain not just your fellow MVLS volunteer, but a resource for you. And with that, if there are any questions, I'd be delighted to take them.
All right, thank you, Tom.
Sure.
Feel free, if you have any questions, put them in, like I said, the Q&A chat now. You mentioned like sharing your email address and phone number. Do you mind if I put those in the chat?
I will type them right now, yes.
But while we're waiting for questions to come in, there's a question I have. For the last slide, you mentioned including like tax avoidance language in the proposed order. Do you have an example like what that would sound like or how that would be written?
How to put it into the into the proposed order?
Yeah.
Well, you know, there's a specific provision in the transfer tax statutes that exempts payment of the charge if a transfer is by court order.
Okay.
And so by citing that section in the order where the judge says, and it is also ordered that this specific transfer is exempt, and a citation to that transfer tax statute, you'll be covered, because
Okay.
that's what the tax office and that's what the transfer office and the recording office are going to read is the order.
So,
364-45.
okay, so we actually have a question. So how do you reconcile the conflict in real property between a will and a deed? Do you bring it to the orphans court?
Certainly. You have to remember that when you say conflict in real property, the interest in real property is evidenced in the land records by the deed. And so what I gather you're saying is that what is written in a deed, you know, the home goes to John, but the deed shows that the dead person still has title. You need a quiet title action. The non-litigation way to get there is to involve yourself or your client in the orphans court to work with either the existing PR or to replace the existing PR if they don't want to act, to appoint someone and ask the court to appoint someone who will execute a deed in conformance with the will. And if they won't, you include the personal representative as a party in the quiet title action. So that's how they kind of marry together. But the orphans court, I don't believe has jurisdiction to make the judicial determinations you need out of the circuit court. All right, I hope that answers the question.
Thank you.
All right. All right, I'm looking at, I'll read the next one here. Home goes to my friend for her life, and then my nephew. The deed never changed to reflect. Single owner dies and nephew is sole heir. Well, there you have, it looks like you have a traditional life estate with a remainderment. And the transfer occurs upon death. And there's no court case that's required. There's no new deed that's required if the events in the deed actually happened. So that's what happens there with the life estate. Difficulties occur, of course. What do you do if the nephew predeceases the life tenant? Then you've got to get into a couple other issues. All right, Muriel, can you give some examples of MVLS client cases that clients have had the wherewithal to resolve through a quiet title action? Yes. The most frequent low bono or pro bono client question we have involve tax liens. And it's not just a failure to pay because the city always gets paid by auctioning off the property. It's the owner of the tax sale certificate and their filing of the action of foreclosed rights of redemption within 2 years. And where we have succeeded is to really fly spec the court files and determine that process and procedure was not filed, jurisdiction was not properly obtained, and we can vacate some of these wrongly obtained foreclosure of rights of redemption. We've helped people redeem where the amounts aren't huge. I mean, the statute sets what the foreclosure lawyers want to get paid. And 9 times out of 10, people who hold tax sale certificates and sue to foreclose rights of redemption never want to become owners of the property. They want the 18% interest on the tax sale certificate. And that's where the negotiation usually takes place, or there might be a contract in place to sell to a third party, and you may have to pay some money to get that third party to release their interest, their executory interest in that contract. But those are the most common things. Other than that, the most common thing we hear from MVLS and low bono clients is what to do when the will says something and they don't know what to do to get a deed recorded or how to draft it. And that's probably the simplest thing, and you can do the most good because it requires the least of your abilities. It is such a basic task. So I hope that's helpful.
Very much so, very much so. Any other questions?
Yeah, if you don't think of it today, again, I'd very much enjoy sit down and have a cup of coffee with any of you guys, because my partner and I, who happens to be my son, we're kind of nerds for this kind of stuff.
All right, well, great. Thank you so much, Thomas. This was great, very informative. But I had no idea about using the quiet title statute to potentially like declare a lien invalid. It was very helpful to know. So I just want to thank, is that another question? Just awesome presentation, thank you. So before like actually adjourning, let me just go over some quick MVLS slides. So bear with me for a second while I share my screen. Okay, can you see the slide says like race equity context?
I can see it, yes.
All right, thank you. So Because I just want to thank you all again for attending. And so just one last thing I wanted to like highlight in the need for this training and pro bono representation for our clients in these types of cases is viewing this issue through like a race equity lens. So this country has a long sordid history of systemic racism, including redlining, blockbusting, restrictive covenants, and many others that has led directly to the extraction of wealth in Black communities. And this work that we're doing is absolutely critical to narrowing the racial wealth gap. It's good to have this in mind because it allows us to better serve our clients and our community. And it's just good to think about like when we're trying to like keep these homes in these families, these homes are hard won. So it's just very important to keep that context in mind. Just some social media, feel free to follow us on social media. Here's all our links. And if you're looking to volunteer, you can visit our site at mvlslaw.org. In the top right is a little button that says take a case. That's our pro bono portal. It looks like this. You can sort by case types and different counties to like find a case that like works for you in your schedule. We have some upcoming trainings that are great, just like today's training. So actually we have a next training on August 18th on what needs to change in the current expungement laws here in Maryland. And then just as this training is being recorded, we have a deep bank of recorded trainings in many different areas of the law. And then just lastly, if you are not yet an MVLS volunteer, please sign up today at this link. And that is all. So I just want to thank our presenter, Tom. Thank you so much for your time today.
Cool.
And your insight. And I want to thank our attendees for joining. And that's all. Take care. Enjoy the rest of your day.
Thank you all. Bye-bye.
Take care.